Boggs, you previously identified as being born in 1999, is that correct?
Yes, sir.
Last 4 digits, social security number 4290. We're here on a pretrial conference. Is there a plea in this case?
Yes, Your Honor, it's a sentencing.
Sentencing.
There's a PSI.
You have a PSI here?
Megan brought it out for the go over.
Great. Have you had an opportunity to go over this with your client?
I did, Your Honor.
Sir, have you had an opportunity to review precinct's investigation report done by probation and parole?
Yes, sir.
Is it substantially correct, counsel?
Yes, sir. There was only one change. I think it's on page 5. It says that in Indiana, he was found guilty but mentally ill. He said that's not correct. He entered a plea to that. There was no trial and there was no.
Well, that's finding somebody guilty. That's the terminology. If you plead, you're found guilty in one of these reports. Isn't that right, Mr. Garner?
Plead right. Okay, it just says but mentally ill, and he's made no defense about being mentally ill. I want to make sure the court understood that. If that's the terminology Indiana uses.
I don't know. I don't know.
Okay.
I don't know.
I don't know that I'm mentally ill. I didn't,
It doesn't mean that you're mentally ill.
Oh, okay.
You have entered. All of us might be mentally ill at some time. What it meant is that the time you did a plea, maybe to diminish the punishment or something like that, you reached an agreement. You see what I'm saying? So we'll
Yeah.
double check what the record says up there and delete that if it's necessary. I'll tell you. There, okay, so the defendant. The defendant shall receive a sentence of 6 years. Mr. Hunley, y'all want to watch this thing here to make sure I'm doing the right thing. You got any paper? You don't look like y'all have any paperwork on it here, do you? This report is a little different than I'm used to having. It doesn't have the same.
Timothy Boggs, you want to have the PSI, you follow, offer to read.
What I've got here is 6 years, drug court, 60 days.
Yeah, well, the defendant shall receive a sentence of 6 years, serve 60 days home incarceration, balance probated 5 years. Defendant shall receive credit. Defendant shall pay court costs. He shall obtain a gainful employment. Defendant agrees to have any and all other. Defendant also remains on active supervision until all court costs are paid. Doesn't say anything about drug court.
He's living in Indiana.
Has he got his 60 days in yet?
No, Your Honor. He's got, I think the PSI shows about 12 days, and then he would have 3 more since they turned themselves in on Tuesday.
Well, he's got 60 days, so you got 15 and 60 days. What are the court costs in this case?
$220.
$220. Okay, well, this is a felony plea, so we'll order a pre-sentence investigation report.
That's it, Your Honor.
Oh, it's already, yeah, it's on the docket wrong. I guess Teresa, keep on doing that.
Got it. If I could interrupt you, you asked me what our understanding was, and I mentioned drug court. That just must have been part of the negotiations. The actual offer was sentence of 6 years, served 60 days home incarceration, probated for 5 years. There's nothing in the plea documents about drug court.
Right.
You know, he's also nothing about him being in jail. So I guess he gets jail credit at this time and the rest of it's home incarceration, but where does he live?
He's got an Indiana address, Your Honor.
See, how do we do in-home incarceration with him being in Indiana?
It's my understanding that they can put the ankle bracelet on here and then GPS monitor.
I don't see, well, what if he leaves? What do we do? what if he cuts it off, or what if he cuts it off, but what if he goes somewhere else, and how do we pick him up? He's not in Kentucky. This is the reason this is, Mr. Garner, what do you have to say?
The only stipulation that I can do to assist this is he'll be an interstate compact transfer. I can ask that the receiving state provide that 60 days on incarceration and force it up there. But I can't guarantee that they will.
No, and you also don't know how long it's gonna take for them to accept him. He's in jail here.
Well, where he'll be an immediate transfer where he is a resident of receiving state in a year. He can go straight back as long as he fills out the paperwork before he leaves. And he'll be put on a travel permit and he'll have 30 days to get that squared away.
Does it help that he's already on supervision with probation in
There'll be a
Indiana?
judicial economy too. They have a mutual interest in supervising the floor.
Well, I'm gonna say, so let him go. You know, I mean, we can't enforce it.
How long has he been in jail here? Waiting this,
4, 5 days,
Here, about 3 days.
okay.
and then he was held, did he get extradited?
No, sir. No, he turned himself in on Tuesday
Turn it where?
here at our jail.
I got a travel permit and stuff, so, and I turned myself in.
Indiana gave him a travel permit to come down here to turn himself in.
No restitution or anything over this thing. Well, let's just put him on the probation, just put him on the probation. 5 years, sentence of 6 years, I guess, it's if. Let's see, print it off here. Shall receive a sentence of 6 years. Probated for 5 years. What are the court costs?
$220.
You pay $220 court cost, I'm gonna put you on probation from here,
Okay.
and then they'll transfer your probation up there on judicial kind, forget the in-home incarceration. It's not worth fooling with.
Thank you.
You understand? And I'm gonna tell you what, though. If you jaywalk, ever since I looked this in-home incarceration, if you jaywalk, I'm gonna revoke you. You understand what I'm saying?
Yeah,
Okay, well, so we'll get the paperwork, he can be released today and soon as
His
he
report with
pays.
his father,
Do what?
we're having a report with his father, Your Honor, same time.
Yeah, both of them report at the same time, and you pay your $220, I'll let you out of jail.
okay, that works. Thank you.
Okay, see.
Thank you, Judge.
Thank you.
Okay, where is Jack Randall?
He's not here.
Has he been served? Is this a initial finding or continuation?
It was convened from last month because he hadn't been served. He was served October the 10th by Sheriff Williams, looks like.
Okay. Some of these things happen down in Tennessee, is that correct?
Yes, and I don't know if that report is attached. I have the card and the number. I forgot to bring it from home because I do have a copy of it. But that was on September 6th for the stalking. It was caught on camera.
Yeah, I'm just asking you, if some of this happened
Yeah,
in Tennessee.
that's it.
what sort of protection you want? There's not an order, is there an order in place in Tennessee?
No,
So you don't have any kind of protection order at all?
not in Tennessee.
In Kentucky, you have one?
Yes.
I don't see it in here.
He's on the emergency.
Yeah, it is, you know, but I'm talking about, I asked if there's any other ones
Right.
besides this one. So, okay, we did an EPO.
Yes.
Well, I don't see a reason not to convert the EPO. He didn't show up, he's been served. What kind of limitations would you like on him?
I
I know it would be like Mars if you do it, but it's not.
I just want him to leave me alone and stay away.
What is the present order, 150 feet or 500 feet?
Right now, he's residing on the property next door. My neighbors, till supposedly he buys a house here somewhere, so.
Has he violated the previous order?
No.
Just continue to put that order in place as a permanent violence order for 2 years. Okay? I mean, you have a signed sworn affidavit. I'll just ask you to raise your right hand. You solemnly swear or affirm that you will truthfully testify in this case.
Yes.
Yeah, I've read your petition and the statements that you lower your hand, your statements, petitions there, and all those are true as far as these statements, threats he made about choking you and the other things are true, correct, that are in that affidavit. You're saying so under penalty of perjury, is that correct?
Yes.
Okay. We'll go ahead and enter it.
Okay. I also I'm not sure, he was served divorce paperwork, so I guess if he signs
I don't
something,
know
he
about
brings them.
divorce, we're just on the EPO, he was served with the
Okay.
EPO, I don't know anything about the
Okay.
divorce,
All
okay?
right. Thank you.
Thank
Do I
you
get
very-
a copy or do I?
You know, it wouldn't do any good if you didn't have a copy, would it? But you won't
Yeah,
get it
I
right
guess
now,
so.
they'll have to be drawn up, I have to sign it, it'll be probably
Next week.
about no, it'll probably be sometime today, I can get you a copy of it, okay? So you enjoy the safety of the courthouse until then, we'll get you a copy of it today,
Okay.
okay?
So you want me to wait?
I don't care if you want a copy of it, you'll have to wait,
Yeah.
okay?
Okay.
Okay, thank you.
Your Honor, this is Chris Davenport. I'm on Zoom.
Good afternoon, Judge Jonathan Lanham for Mr. Carver.
Okay. What do we have here? Is it a motion is set for trial? Is the discovery finished in this? Somebody doesn't have their camera on. here.
Yeah, Judge, that's me. It shows that it's on, but not that anyone really usually don't want to see me, but I'm not sure why it's not working. Thank you.
Well, Clay Hunley's already gone and Mr. Lavitte's not here today. They usually are the ones that set the technology up for us.
It's on my end, I believe, Your Honor. It's showing.
It's on your end because obviously technology is like top notch.
Judge,
Okay.
I hope you're okay with me proceeding as is. Maybe you can recognize my voice, I hope.
Well, okay. What has discovery been completed?
Judge, I'll give you an update. We were before Your Honor in August, and I have received in 2 pieces additional discovery for Mr. Lanham and Mr. George. The most recent I got today. I am assuming that is complete. I sincerely hope it is. We're kind of at the point in this case, Your Honor, that my client's going to have some dissipation claims against Mr. Carver regardless. And if there are still items and assets and transactions he has not disclosed, I'm at the point at this juncture of just adding those to my dissipation request at any rate. It's kind of the law of diminishing returns in this case, frankly.
Judge, we've provided everything that's been requested as of August. What I sent to Mr. Davenport today was just the digital version of the interrogatories that we sent several weeks ago. I got that over to Ashley today. So it's our outbound interrogatories that have not been responded to yet, and we're still waiting on the conclusion of that discovery from Mr. Davenport and Ms. Carver to proceed.
What are you owed from Ms. Carver? What kind of discovery are you owed?
Just responses on interrogatories at this point.
I mean, what are those interrogatories? Are they 2 pages, 20 pages, 50 pages? Mr. Davenport You have those, how long do you anticipate for you to answer those?
I think it's probably about 10 pages, less than 10 pages.
Mr. Davenport, do you have those in your possession?
I'm not sure to what Mr. Lanham is referring, Your Honor. All I've gotten today so far is an email from Mr. George that provides information relating to Mr. Carver's alleged loan payments from his grandparents and information regarding the stuff we discussed in August, the $100,000 note, loan payments made to or by Sarah Turner, and ledgers of the hunting business.
Well, he claims that he has interrogatories that he has presented to you that have not been.
Yes, sir. I understand that's what Jonathan's saying. This is the first I recall being made aware of that. I'm assuming he's talking about supplemental responses.
No, not at all. I mean, we had prior to a few weeks ago, we had not actually sent out any interrogatories to propound upon Mrs. Carver at all.
Okay, so I'm sorry, Your Honor. Then I misunderstood what Jonathan was saying.
Why
Right.
did you
My
not send
office.
interrogatory? Wait just a second. Have you not sent interrogatory?
We did many weeks ago.
When did you send them?
It would have been September.
Well, this is October. So has it been over there a month?
I think it was the last Monday in September, the 29th, I believe.
Okay, well.
And I know that they were received because Miss Gilbert, Mr. Davenport's associate, sent me an email confirming that receipt.
I'm not gonna argue about dates, or anything. Mr. Davenport, can you check your electronic files or whatever you have to see if you received those interrogatories and give us some idea on when you can respond to?
It looks like they were received on September 29th. And the fact that Mr. Lanham has referenced Miss Gilbert supports what my assumption would be, and that is she is working on responding to that. Of course, the responses aren't even due until sometime next week. So he would not have known her identity otherwise.
Okay. Okay, well, here's the deal. You, since those interrogatories are not finished yet and are not due yet, I don't see setting this for trial. So what I'm gonna do is I'm gonna put a drop dead deadline date on this thing. We're gonna be back. I want you, by, let's say, November. Let me see. I don't want to wait till the next rule day in case there's some disagreement. The next rule day here is November the 20th. By the 13th of November, I want y'all to file any motions if there are any discovery issues left. Okay? It's by the 13th. If all
Notice those for the 20th, Your Honor, if there are any.
If there are any problems, we'll notice them for the 20th. And if there aren't any problems, y'all won't have to wait till the 20th. I've got my calendar. And if y'all got discovery complete, we can go ahead and pick a week up toward the resolution of this thing. But I'll call in the office and we'll pick a date out. Okay. And I anticipate this will probably be a couple of day situation. Am I
Yes,
correct?
sir. My anticipation was to probably ask for a day from Your Honor. I know this circuit does not routinely give out 2 days. And I was optimistic maybe we could do it at one, but it will be a lengthy trial.
And there's gonna be a lot of numbers and I don't want to get fogged over here too much. Now, let me ask you, because Mr. Carver is involved in some other court actions here that might have some effect on what assets are available or what he received or what he didn't receive, sort of thing. Are we gonna run into any problems there where he will not want to testify about things, Mr. Lamb?
Judge, I think he'll have to invoke the Fifth Amendment privilege.
Well, until then, I can make a good argument that until that issue is resolved, if he's gonna take the Fifth Amendment on a bunch of things in this divorce action, Mr. Davenport, it would probably not be fair to your client to proceed.
Well, Judge, of course, the court, to the extent he pleads the Fifth, cannot use that against him in his pending criminal case. But I believe the court can make any inferences from his pleading the fifth in a civil case. So,
Well, I'm just talking about what if he comes in here and refuses to answer anything about assets or transactions or things like that. I mean, I'm not gonna be able to situation just to speculate. I'm not saying he will do that. We're just address.
I think the biggest property dispute you're going to have, Your Honor, will be over the assets that Ms. Carver will show existed that have not been accounted for either by way of where they are now or any sales proceeds that were received in exchange for those items. Those are dissipation claims. And frankly, once she shows those items are gone, it becomes Mr. Carver's burden to explain what happened. And if he pleads the fifth on those matters, I think I don't think that prejudices her. I think it prejudices.
On dissipation claims or existing properties, I don't think the Fifth Amendment will get him there. But I just want for both of you, to understand that if we get into that situation, if there are any assets that you claim Mr. Carver had under his control that are involved in the other action, we won't have a problem. In other words, if you're not claiming any dissipation of assets that he received, if he did receive anything unlawfully, then I would assume that you would not claim any marital interest in unlawfully gained situation.
No, sir.
Not that he did. So I'm not saying. You follow what I'm saying?
Yes, sir.
Okay, well, we'll just go ahead, and when I get back to y'all, we'll set us a couple of days and see how we go on it. Okay, thank y'all very much.
Thank you, Judge.
Thank you, Your Honor.
What a day inside the courtroom. 3 stories, 3 verdicts, and 1 powerful message. Justice doesn't play favorites. From the calm warnings to the emotional breakdowns, every moment we just witnessed had something bigger behind it. A fight between pride, truth, and survival. Think about it. The first man who stood before the judge thought his probation was just paperwork until the gavel came down like thunder. The judge didn't yell for drama, he spoke for accountability. One wrong step, and his freedom was gone. It wasn't about punishment, it was about control. The courtroom reminded him that second chances come with strings attached. Then came that divorce case. Quiet, cold, and cutting. You could feel the tension through the screen. No shouting, no tears, just silence that screamed louder than anything. The husband sat there, trying to hide behind the Fifth Amendment, thinking that silence could save him. But the judge knew exactly what that meant. In civil court, silence isn't safety, it's suspicion. You could see the frustration build, the judge fighting to keep order while truth slowly exposed itself. It wasn't a shouting match. It was a chess game of law and logic, and in that match, silence lost. And finally, the woman who came forward, trembling, tired, but unbroken. She didn't ask for revenge, she asked for peace. After being stalked, threatened, and ignored, she walked into that courtroom carrying more courage than most people ever will. Her voice didn't shake because of fear. It shook because of strength. When the judge signed that 2-year protective order, it wasn't just paperwork. It was protection. It was freedom. It was the law finally saying, "You're safe now." 3 completely different cases, but the heartbeat behind each one was the same. The system doing what it was built to do. To protect, to correct, and to remind everyone watching that your choices will always meet their consequences, and maybe that's what's most powerful about courtrooms like these. They don't need flashing lights, they don't need chaos, just truth. You can feel it in the judge's voice, the lawyer's tone, even the silence between their words. Justice isn't always loud. Sometimes it's quiet, heavy, and deeply human, so as the gavel drops one last time, think about what you just saw. A man warned to straighten his path, a husband cornered by his own secrets, and a woman finally shielded by law. 3 different battles, but all fought in the same place, under the roof where truth has no escape. That's the real power of justice. It doesn't always destroy. Yeah, sometimes it rebuilds, sometimes it protects, sometimes it simply listens. And that's why we keep watching, because in every courtroom, there's more than law, there's life. If you felt the tension, the emotion, and the humanity in these moments, hit that like button, share this video, and subscribe for more real-life courtroom breakdowns that show how justice truly unfolds. Because in this courtroom, every word, every silence, and every gavel strike tells a story you'll never forget.